Good afternoon. Thanks so much for tuning in to today's event. I'm Carolyn Bobb, Vice President of Communications at the Alliance for Justice, an association of nearly 140 members committed to building power, transforming courts, and securing justice for all. Our speakers today come from two of our valued member organizations, Earthjustice and the Native American Rights Fund. Today's conversation is part of our ongoing series, Holding Court, Conversations with AFJ. This series features leading activists, scholars, and attorneys discussing current political and social justice issues. This week marks Trump's 100th day in office. And a little over a week ago, we celebrated Earth Day, so it is the ideal time to be talking about environmental rollbacks under the Trump administration, federal and state court cases that are shaping or hindering environmental justice, and how environmental issues impact various groups, including tribes. We're honored to have two environmental justice advocates who have dedicated their careers to this work. Sam Sankar from Earthjustice and Daniel Cordalis from the Native American Rights Fund join me today for Holding Court, Environmental Law in the Age of Erosion. Sam serves as Earthjustice Senior Vice President for Programs, where he leads the litigation and lobbying departments and oversees the organization's overall advocacy. And he has been working on environmental issues throughout his career, which includes service as a line attorney at DOJ's Environmental and Natural Resources Division and as Deputy Chief Counsel of the Presidential Commission formed to investigate the 2010 Deepwater Horizon oil spill. Thank you so much for joining us, Sam. And we are also joined by Daniel, who serves as the lead of the Tribal Water Institute for Native American Rights Fund, where he supports tribal water interests through his legal and policy expertise. Daniel has nearly 2 decades of experience working with tribes to protect their water, natural, and cultural resources. Daniel has worked previously as a tribal in-house counsel, as an associate attorney with Earthjustice, and as a legislative associate with the National Congress of American Indians. Daniel, before we get started, why don't you just tell us a little bit more about your organization?
Yeah, thanks, Carolyn. Really good to be here. And like Sam said earlier, we're really happy to be a part of this coalition, this group. So the Native American Rights Fund was created in 1970. It's headquartered in Boulder, Colorado, and it's a national nonprofit legal services organization serving tribal nations, tribal organizations, and individual tribal people. We have almost 30 lawyers and almost nearly 60 staff in 3 offices, Boulder, Washington, D.C., and Anchorage, Alaska. And we handle a wide range of issues addressing tribal nations and tribal people, civil and voting rights, treaty rights protection, religious freedom, tribal jurisdiction cases, just to name a few. Our mission at NARF is that the Native American Rights Fund holds governments accountable. We fight to protect Native American rights, resources, and lifeways through litigation, legal advocacy, and legal expertise. And of course, over our 55 years doing this work, that work has changed quite a bit. But we're in it to develop the field of Indian law to make sure that tribal nations have their treaties recognized and respected, and that we have tribal people have every right that every other citizen has. So that's just a quick background, so thank you.
No, that's perfect. And I think I just learned something. I know we're going to learn a lot throughout this conversation. So just a quick housekeeping that we will have an opportunity for the audience to ask questions, and they can be submitted in the comment box and whatever platform where you're joining us. And then also note that AFJ staff members will be monitoring the comments, and any comments that are not in line with our mission or discriminatory may be deleted. So now let's get started. So first question, Sam, I'm going to start off with you. We've just mentioned President Trump's 100th day in office occurred this week. And what have you seen from Trump's second term in regards to environmental rollbacks or policy shifts during this first 100 days? And then a 2-parter on that. What major shifts in the policy could we expect for the rest of the term?
Well, I mean, I think everybody who's been watching the news knows that the first 100 days have been incredibly active. They've done a lot. They've said a lot. And the president in particular has said a lot. The on-the-ground impact that we've seen most clearly is on funding programs. The president has done, 2 on-the-ground impacts. One is in interruption or attempted interruption of all kinds of money flowing out of the federal government. And in our world, that very much includes grants of money to all sorts of entities issued pursuant to the Inflation Reduction Act or the IIJA, both of which are some of the most important climate and environmental justice legislation that's been done in recent decades, even if they weren't titled as such. The money that goes out through those laws is super important. And the Trump administration, true to form, did all sorts of things through seeming administrative inattention to outright legal refusal to actually move that money. And that caused real harm to people. So that's why we actually waded in and filed a lawsuit regarding that. Many other organizations have done similar things to try to ensure the flow of money. The other big thing, of course, has been the massive attack on the federal workforce. And that federal workforce, the environmental agencies have been a special target. And the Trump administration wants to just decimate the folks who provide the technical, economic, and legal support for running the nation's regulatory apparatus. And while Earthjustice and NARF at times sue the government quite often, and we're not always happy with what those agencies are doing precisely, none of us, I think that the answer is cutting these agencies to the bone, or even further than the bone, in the way that the Trump administration hopes to do. So I'd say those are the big attacks that we've seen so far. Now, what's coming next? If you look at a lot of the policy pronouncements from the administration, what they seem to be saying is we're not going to be following the regular rulemaking process to do a lot of the regulatory rollbacks that we've expected. The last time around, the last Trump administration, I'd say they largely followed the standard Republican playbook of kind of going through the technical notice and comment process to try to pull back anything that seemed costly to industry. This time they're saying much more aggressive things, such as, if we think something violates Supreme Court precedent, we're just going to withdraw it with no notice and comment. And, we think we have the authority to do that. Not many of those sorts of things have actually landed yet. So it remains to be seen how much the threat or promise actually carries forward. But regardless, we're going to be there ready to take them to court.
Daniel, you seeing the same sort of things in your community?
Yeah, definitely. And outside of kind of environmental type programs, we see kind of those funding cuts hitting the Bureau of Indian Education and the Bureau of Indian Affairs. Places like one specific one is NARF has been involved in suing the BIA, Bureau of Indian Affairs, for funding cuts and staffing cuts to schools that are serving tribal communities through the Bureau of Indian Education. So, yeah, so while there are specific impacts, those funding related and staffing related impacts, we're kind of just waiting to see a lot of things too. One thing our communities have been really centered on is the monuments, national monuments. Especially there's several that were designated on behalf and to support tribal resources and tribal interests. So we're kind of waiting as well to see how a lot of things land. The staffing at agencies is really important, with even Department of Justice, particularly when the ones that often bring affirmative litigation on behalf of tribes to protect tribal resources. Concerns about cutting certain field offices there are really get us worried about the ability of the government to do their job as tribal trustee on behalf of tribal nations.
And now with the Republican trifecta at the federal level, when you talk about money and appropriation, right, that's supposed to be going through Congress. What do you see? Do you see the Republicans in Congress changing course from these first 100 days? Do you think there's anything that could happen that might change this course, or are there any laws in place that might be able to stop some of this?
You want to take a shot first, Daniel?
I think this is probably more centered towards you.
Yeah, well,
thanks.
So we're still, even though the last 100 days feels like 100 years to many of us, it really has just been 100 days. And one of the things we're all reading about, and I don't know whether it's true, is that there's been a significant slide in political support for the president's policies. And it's really not clear, to me at least, for even reading all the news, how durable the slide is. What does it mean? What is clear is that the president doesn't seem particularly interested in paying attention to it. So the durable limit on the president's agenda is going to have to be either the advice of the people around him, which doesn't seem to be great, because I think he's surrounding himself with people who are inclined to encourage his worst instincts. It's got to come from Congress, which currently isn't providing it because I think they're often scared of what he might do in terms of retribution. But Congress is influenced by public opinion, I think, much more clearly than the president seems to be right now. So I think the limit comes when public opinion, business opinion, donor opinion shifts, and they're putting pressure either on the president directly or through Congress to get the president to behave differently. In terms of like passing laws to change the way the president acts, I'm afraid certainly with the current Republican trifecta, that's not likely unless there's a real precipitous, massive slide in public opinion. That I would say is hard to imagine, but it's hard, the unimaginable seems to happen every day now. So I'm running out of predictions.
Let's take a quick look back. So President Biden signed the Inflation Reduction Act in 2022, the single largest investment in climate in the history of the US. Can we talk a little bit about how Trump is dealing with IRA and all the other Biden climate initiatives? And Daniel, I want to specifically ask you about the agencies such as the EPA. How are they impacting the tribal issues? And have you seen a big shift from past administrations?
Sure. Yeah, I'll take up that first part, kind of reflecting at least what we see. The IRA had a lot of really useful programs to support tribes on their, I'll say water work, but also other land conservation work. Tribes in the Colorado River Basin were really interested in using IRA funding wherever they can to generate some conservation programs, but also water efficiency programs, infrastructure programs. Really important for developing healthy communities, really, that are centered around water. And that's kind of where we still are with a lot of tribes. We're not talking about retaining a lot of those things. We're talking about building them for the first time still. We had tribes in the Klamath River Basin that were working on restoration after the biggest dam removal in American history, right? The restoration of an incredible ecosystem that a lot of their federal partners and a lot of organizations and tribes themselves were losing access to funding based on the IRA there. And so there's that type of work, that type of I don't want to call it catch-up work, but there's some of that for sure, but there's some of the actual land restoration, protection, and reclamation type work that tribes are involved in. And the second part regarding the EPA and kind of how the changes are that we've seen there. I mean, it's been pretty stark. I think the EPA, at least under Biden, was doing some really useful things related to delegation of authorities for tribes and requirements for states to at least be more aware of and to be actively considering tribal rights and interests. So far EPA has been on one track to basically strip that agency down, and we're not seeing anything but stripping down of regulations being really proposed. And so we've had industry kind of asking the EPA to take down some of the rules that were actually intended to support tribes' water quality standards, and the combination and the release of the recognition of tribal water quality standards, and just real questions about how much the agency, and dealing with the Sackett decision too, a couple of years ago, how much they're going to be willing to step into a space to continue to think of tribes and their trust responsibility as a separate but important part of than everything else they're doing. Let's say the taking away here, but also the retention of those key programs to support tribal nations, along with the other parts of the deregulatory work they have. So it's a real concern for us to see how everything that's happening, the push as tribes kind of get caught up in what I would think is the push for stripping down the government, but that retention of both the trust responsibility and the tribal rights, which are rooted in federal law, right? How do we make sure those don't get out of focus too much or really disappear in kind of the agency's purview?
So I want to have this super smooth transition to the courts from what you just said. And so, Sam, last term we saw the big decision from the Supreme Court with the overturning of the Chevron deference. So can you begin to explain to our audience like what Chevron deference was, and why it's so incredibly important? Oh, you're muted, Sam.
So we all know that there's federal law includes both statutes that Congress writes and regulations that agencies write pursuant to those statutes. So the Clean Air Act says, we have to protect the air in certain ways, and it gives instructions to EPA about how to actually go about writing regulations that'll do that. The Chevron doctrine referred to I think it was a 1984 decision in which ironically went against the environmentalists. It was a case in which there was this word stationary source in the Clean Air Act, and nobody really knew what a stationary source meant. Does that mean a factory with all of the chimneys is considered one source, or does it mean all the chimneys are individual sources? Does it mean that many factories in the same neighborhood are all one source? Nobody really knew. And the EPA made its judgment about how to think about that. And environmentalists weren't happy, and they challenged it. And the court, Justice Stevens, liberal justice, said, no, in these sorts of situations where it's not clear what the statute means, where it's kind of susceptible to multiple interpretations, we're going to give the agency some latitude in interpreting this. We're going to defer to the agency's interpretation of this law, because guess what? There are lots of different ways you could read this language, and we're just judges. We're sitting here in this room, we're reading this one case. The agency has tons of resources to go find out how this would play out. It has experts, it has economists. They're reading and they understand the broader statutory context. So we give them some latitude in reading these laws, and we defer to their interpretation. Well, that doctrine really drove some conservatives nuts, because they believe that, number one, all these laws, no matter how vague the language, a judge can determine the final meaning of them. One. And number two, they viewed this discretion that agencies have as something bad that essentially enabled the growth of a regulatory state, that agencies were using this discretion to issue broader and more stringent regulations on industries. In fact, I think environmentalists would tell you this cuts both ways all the time. Many fights from enviros are about resource decisions made by the Department of the Interior, where they want deference for how to implement forest plans or whatever else. So it cuts both ways. But by removing the decision, or by saying we don't believe in this idea of deference anymore, the Supreme Court throws a lot of long established regulations into question, because in many cases, the courts upheld those regulations by saying, look, this is within a permissible construction or reading of the statute, so we're going to leave this one alone. And now we're going to see, because of some other decisions the Supreme Court issued last term, more opportunities for the industries to come in and question the validity of those regulations by saying, look, we think that the agency overread the statute in issuing this particular regulation. And the only reason it's around with us today is because of that Chevron deference approach that people have been using. That's gone now, and we want to look at it again. And in fact, the Trump administration has issued an order saying, hey, we want agencies to go look and find regulations that may have rested on Chevron deference, and we want them to throw it out. So it's really, for the Trump administration, it's not about any sort of principle. It's just about an excuse, in my view, to throw all these things out for any reason at all.
And Daniel, do you see that across, like you mentioned how the tribal laws can be separate, but they are based on some federal laws. Are you seeing this impact too in any specific ways?
We haven't seen it actually play out yet in real ways that affected us. We've been concerned with it. Some litigation has been raised, where parties have kind of raised the idea that this might be subject to the lack of Chevron deference there, but we haven't actually pressed it out beyond that yet. So it's kind of it's been pretty recent, so it's kind of a little more wait and see on that.
About the recent Supreme Court decision, Arizona versus the Navajo Nation, has that impacted tribal authority over environmental regulation in any way?
Not yet, at least not that I'm really aware of, but we do see it being cited a lot in a lot of cases. I mean, that case was about the federal government's responsibility under its trust responsibility to support tribes and their really development of water resources, treaty protected water resources, where the court there said, well, yes, we understand that the tribes have a reserved right to, in this case, water, but there's no, concurrent right on the federal government to do anything about that water, to actually develop it on behalf of the tribes. So the existence of the right is there, but that's kind of where it stops, at least for under the Navajo case. So that's, that was a trust responsibility case. We're seeing it cited regularly to say that, well, the government doesn't have to do these things. That's often cited incorrectly in that way, but so there are a lot of folks trying to take a very expansive view of the federal government doesn't have to do anything to support tribes. But we haven't really seen it been applied in a way that creates new obstacles. I mean, it was kind of an affirmance of a long kind of position held by the United States government and the Attorney General's office that the trust responsibility is kind of very narrow. The federal view of that is, which is of course a problem I think tribes have inherently with the way that the United States has always kind of viewed its trust responsibility.
And Sam, you touched on this briefly. The Supreme Court also heard arguments in the 7-county infrastructure versus Eagle County, Colorado, and Oklahoma versus EPA, and Pacific Corp versus EPA. Can you talk a little bit about what we should know about those cases and some of the potential implications that can come from those decisions?
Sure. I can talk in particular about the 7-county case in which we're actually representing the environmental parties in the case. The case involves a question of what kinds of impacts that one has to consider under NEPA. NEPA is the National Environmental Policy Act. It's the sort of core statute of environmental law. And what it basically says is before the government makes big decisions, it has to think about the environmental consequences of those decisions. It has to look before it leaps. So the statute the statute was written a long time ago. There have been a body of regulations that have grown up around it. And in essence, we've all agreed that the kinds of things the agency has to examine are the things that are reasonably foreseeable outcomes of the project. And the case involves a question about a railroad being built in a remote part of Utah. And the only reason they're building this short stretch of railroad is to allow a huge amount of oil and gas, of tarry crude oil, this sort of waxy crude oil, to be removed from this area and brought to market. Everybody knows that building this 12 miles of railroad means bringing this enormous amount of waxy crude into the market. And everybody knows that waxy crude is going to a couple of different refineries in Louisiana. So the argument from our clients was, hey, look, you've got to think about the consequences, the climate consequences of bringing all that massive amount of very heavy crude to the market in terms of emissions. And you've also got to be considering the environmental justice implications of expanding the refinery capacity in Cancer Alley to accommodate all this new crude delivery. The railroad's position, the government's position is that these are beyond the scope of what anybody needs to analyze under NEPA. And so we argued that issue in court. We're expecting, in fact, I was expecting a decision today. Maybe it'll be tomorrow. We have another decision today. But what people need to know about this is that the decision in the case, and with this court, I generally am pessimistic about environmental law outcomes. The decision of the case could redefine the scope of impacts that agencies need to evaluate under NEPA before making decisions. So I try to remain optimistic, but if I were a betting person, I would say we're going to get a little less NEPA when we're done from this court.
Let's switch gears a little bit to state courts. And so we've seen the Montana State Supreme Court rule that Montanans have a right to a clean and healthful environment because of their state constitution. Now, are we seeing any other states emerging as leaders or battlegrounds where there's going to be environmental litigation coming through the state courts?
Well, yes. New York, Vermont have passed climate superfund laws that aim to hold fossil fuel companies to account for some of the impacts that are being caused. Those are the Trump administration has issued orders essentially targeting those things, saying we want the Justice Department to find ways to say that these laws are preempted. There's of course all of the state law nuisance suits that the Supreme Court has so far been unwilling to kind of remove out of state court. They've stayed in state court. And then finally, as you mentioned, there are these state constitutional law cases in Montana and recently in Hawaii as well, where we were able to work with other groups to get a big victory and change the way the State Department of Transportation plans new highways and transportation sectors because of Hawaii's constitution and its concern for a clean and healthful environment. So, look, we've been watching an erosion in federal environmental law that's gone on for years, Democratic and Republican administrations alike, because of conservative court interpretations of our environmental laws. And that's one of the reasons why we've been going for years to the state courts to build up our work in state courts, public utility commissions, and administrative bodies to try to hedge against that.
And Daniel, from your work with tribal water rights, what are some of the most pressing legal or political challenges that tribes face in securing and protecting their water resources?
Yeah, there's so many. I think one of the ones I think to start with is just history, right? Everything's been developed primarily to the exclusion of tribal water interests, except for when absolutely needed. And so most tribes, let's just put some context, as we have 570, I think 6 tribal nations, federally recognized tribal nations throughout Alaska and then in the lower 48, and we have 39 Indian water rights settlements. Of course, there's a few more adjudications that have actually decreed tribal water rights, but for the most part, absent, let's say, Alaska, which doesn't have federal reservations for tribes except one, tribes don't have their rights confirmed. Tribes don't really know what they're entitled to. Therefore, it's hard to enforce. It's therefore hard to rely on. And so that's it. We see in the Colorado River Basin, let's say, where we're having major issues with climate change and renegotiation of an important management structure now to deal with water reductions. And tribes are still kind of outside saying, hey, we need to get in. We need to be able to get in. We need to be able to finalize our rights and get these decreed rights from the courts, and so we can actually kind of plan around that. Practically, and I think this gets to the question, Carolyn, is that accomplishing these types of things is really hard. It takes a long time, costs a lot of money, and they're subject to politics, right? You have the states on board, you have the federal government on board. Then even when you have all of those things, let alone all the surrounding water users, let's say you can find an agreement with all these folks, often you need Congress to actually agree and pass legislation to do that. And we know how hard that is. In the last Congress, we had, I think, 12 tribal water rights settlement bills, some new, some amendments that were addressing significant water issues, including the Navajo Nation and Hopi, basically in trying to figure out the last key puzzles to the Colorado River Basin that Congress just didn't have the appetite for. And so while we had Republican states, while we had Democratic states, we have these groups. A lot of these issues are to be fair, often nonpartisan because it deals with everybody in a basin. We still run into budget problems. We run into folks who don't really agree with tribal politics, possibly tonight in Congress, and they're just subject to I'll easily call them the whims of Congress, right, in politics that they just would lose out to. These are rights that are over 100 years old, 150 years old, and the political environment largely tied to the price tag of these just can't stomach them. So,
do you have any examples of past successful collaborations between tribal nations and other entities in resolving any of these water or environmental issues?
Sure. Yeah, there's the flip side of that. There's a lot of good successes, and that's why we have partnerships. Let's say the NARF has a really good partnership with the Western States Water Council to solve these, because we know that tribes working in collaboration with other water users in a local level is going to actually be the result that's going to last the longest. Tribal water issues, period, are basically the same sets of users along these river systems that have been there for 100 plus years, right? And tribes, of course, much longer. The Klamath River Basin's one where you have tribes, NGOs, maybe a little less. Tribal power there outweighs most other power there and the rights there. But that's been something that's really affected positively the health of that river and hopefully the long-term vitality of that river. Montana's been extremely good in settling their tribal water claims, to the point where I think they've effectively settled all of theirs through a reserved rights commission. And in this Confederate Salish Kootenai tribes, they had a $1 billion settlement that included a lot of tribal infrastructure, but a lot of non-tribal infrastructure as well. And I think we're in that, while that's recent, it also included a land part with the National Bison Range. We're really helpful with that kind of community-oriented focus. When you have tribes, you have the local ranchers, and the state kind of all pitching in, really can get into a lasting solution where everybody feels like they've been heard and feels committed to the success of this.
So you just touched on this. How can Indigenous knowledge and cultural perspectives be better integrated into the broader environmental policy discussions, and especially around climate change?
Yeah, it's a terrific question, because it's a real emerging issue. I mean, on one thing, I think it's really fascinating to know that this Indigenous knowledge is really finding a foothold when it was kind of suppressed for so long, and just these concepts of how tribes have viewed the world, right? How you actually live in and protect the world, and how you view the seasons of change, and just kind of what happens on the ground. It's different, but it reflects also, when you look at it side by side on a kind of Western science perspective. I mean, there's so much overlap, right? It's like when certain things happen on the ground, you can expect these types of fish to be in the river. So those are the things you look at. And you're like, if we can create this habitat, then we will get this back. Probably the most pronounced place or area of a policy and work that's happening is in fire. Right, in fire management, forest management, where tribes, especially along the West and the Northwest, have used, and this has actually happened all over the West, tribes have used fire historically to maintain landscape, to push wildlife, to draw wildlife places, and to kind of take care of the land. 20 years ago, people would have thought you're crazy for starting fires, right? And we were all about suppressing fire. And now we have this real wow, that was actually useful. This was the way we could have been maintaining these forests. And I look outside, I live in Southern Oregon, and I see dead trees everywhere. And that's because we weren't cutting them, we weren't managing the forest, because we were afraid of fires. And so now fire is more our friend. And we see, how do we actually change the way we look at policies to support this type of work instead of being afraid of it?
And Sam, I want to get your perspective on, I know Earthjustice is always focusing on how climate and environmental issues impact marginalized communities. So kind of the same question, how can policy be better served by listening to the people who are oftentimes most impacted by the biggest environmental issues?
Well, I mean, where to begin? There's a couple of things that matter a lot. One is that we have strong environmental laws, and there's definitely been differential enforcement. There are places in this country that meet the requirements that the laws specify, where people aren't thinking about asthma as a daily reality of life, where people know that their water is clean, their air is clean, and all of that. And then, shockingly, there are many places in this country that have just been left out of that equation, altogether. And one of the most important things to learn from communities that have had to suffer that is that they are there, that they exist, that our environmental laws aren't just laws on paper. They need to be enforced, they need to be applied, they need to be administered with strong regulatory presence. And that has been lacking. And the Biden administration at least made steps towards getting better on that. Unfortunately, the Trump administration seems ready to take 4 steps back. The reason you need to hear from communities that aren't getting the benefit of our environmental laws is that they deserve to get the benefit, number one. Number two, they have insights on how to improve conditions on the ground that we aren't going to have from Washington, D.C. and New York City and places like that, solutions for Louisiana. We should be talking to Louisiana. Things are different down there, and the communities that are living with this stuff need to be consulted and thinking about how to solve them. So yeah, there's a moral imperative, and there's an advocacy and sort of outcome oriented need to know.
All right, we have our first audience question, and this is for either of you if you're able to speak on it. The question is, curious if you can speak to the impact of the recent Greenpeace decision and uplift any insights for organizations fighting all pipelines moving forward.
I guess I can share a few thoughts. You know, the Greenpeace decision in which a jury awarded the energy company a substantial amount of money and damages for Greenpeace's behavior in that case, or alleged. And I don't want to endorse anything that was being said in that lawsuit, but it's a slap suit, right? This is a strategic litigation against public participation. It's a lawsuit less about the immediate case than it is about deterring anybody from filing a similar kind of lawsuit. And that impact is significant, right? There are organizations like NARF and Earthjustice that have the profile and the respect that might allow them to weather this kind of an attack. But it definitely puts fear into the hearts of organizations as well as potential clients. It's a real scary thing. And that goes quadruple when it's coming potentially from the federal government itself. And we've seen in orders over the last several weeks that the Trump administration is interested in attacking, say, the C3 status of universities, organizations with which he disagrees. And I think that's also a risk for all of us. So I think for organizations that are fighting oil pipelines, you need to recognize that these are going to be tough times. The administration is trying to grease those things, which makes it easier to challenge because they're not following the laws. On the other hand, there's a vindictiveness in this that we all have to be prepared for. And that starts with being really compliant with the laws that govern how nonprofit organizations work and how C4 and C3 organizations interact. And this is my chance to plug the Alliance for Justice for helping us all stay on the right side of those rules. And we value you tremendously for that.
I love a good plug. So Daniel, I want to ask you just, is there anything you can tell our audience about what the Native American Rights Fund is planning to do or doing, or how anyone should get involved with trying to fight back against what we know is going to happen in the next 4 years? Are there things people should know? Are there resources that you provide or things that you would like people to know that might help your organization?
Sure. Well, we're a 501c3 nonprofit, so funding also always is helpful for us. Start there. But just, I think Sam touched on this a little bit when we were talking about just the public involvement. I mean, I think there's a lot we can do as a public to make sure everyone knows that we're aware and care about certain things. And so following issues, speaking out, writing, putting things in your newspapers, putting things that you care and you think X or Y is wrong, I think is extremely important. We're following, the things that we're most concerned about, at least these 4 years, are often the same things we've always been concerned about. I mean, while this administration can present its own unique challenges, we've also been fighting a really difficult but a difficult kind of relationship with the federal government for 200 years, right? And so it's just kind of where our focus is, and thinking about the protection of our lands and resources here. Where the last administration we're thinking about protecting them, but restoring them, and now we're trying to protect at least the rights and our ability to maintain and not have these things degraded in the next 4 years as much. I think is really what we're looking at. We have a number of resources. Our social sites have a lot of ways for people to follow our work and to participate in our work. And so to the extent that that's helpful, I think that would be great for people to do. And I think a lot of our interests, their land-based interests, will be dovetailing nicely with Earthjustice's too. And we're both concerned about how the monuments are treated, our protection of the American public and the tribal rights to be on and use those lands, and as the way they were intended to from the beginning. Also, the development of resources on public lands we're concerned about. We have such a push towards development of certain minerals, which we need for certain reasons, but also we're talking about public review and participation in those. Let's say NEPO. We're definitely concerned that the rights and the really kind of the sacred cultural values on those lands are protected. against total destruction. And we've lost, let's say in our Oak Flat case down in Arizona, the tribes, and there's a cert petition right now in Apache Stronghold, where tribal groups are trying to basically make a last stand against the Resolution's copper's land swap that'll eventually create a huge copper mine in Arizona that's going to totally destroy a tribe's most sacred area. And this has been a long time coming. It's been over 10 years in the making. But the case law on this has been going on for over 50 years, that we just don't have that kind of protections on our public lands that respect tribal, cultural, and religious activities. So we're involved, NARF, in a lot of different ways. And I think just really kind of the more eyes we can have this, and the more ears we can say that we care about this too, this stuff's important, will be really the most helpful for us.
Great. We just got another audience question in here. So do you have any advice for state organizations who are stepping into the environmental justice space during this time? And what areas the organization can contribute to this fight without necessarily relying on grants and federal funds?
Well, one thing there's the environmental justice space is enormous, and there's all kinds of support that is needed. We don't accept any grants or federal funds, and I'd like to think we help with the movement, and we play in the space. But I think the biggest piece of advice I would have is to work directly with environmental justice leaders and communities and figure out what they need or want, rather than figuring out what you want to do in the abstract first. And I think one of the things that you may hear is that there was a lot of money promised through the IRA and the IIJA and the grant compliant, requesting, getting grants, sustaining grants, reporting on grants. All of that stuff is very hard. And I think even, we've seen this administration try very hard to affirmatively interrupt the flow of all that money. But the other thing they can do is they can just say to people, you're not complying with the terms of the grant. Your report isn't good enough. This isn't the right kind of request. And so if you're a state organization that wants to help in the environmental justice space, I can tell you that there's a lot of need for people to just help with grant compliance for community groups and other groups that are trying to make use of IRA and IIJA funding.
Another audience question. How do you balance the possibility that even favorable court decisions could be ignored by Trump? Then what?
Well, as for me, the question is balance it against what? And there's never going to be an instance in which I say we're not going to court unless the court says I'm not going to bother. The solution to lawlessness is not less lawsuits, it's more lawsuits. And what we're seeing is the Trump administration not refuse to show up in court, but they're playing games in court. They're coming in and saying, well, we mostly complied with what you had to say, or we don't believe we have to answer that question, or, that's none of your business, Judge. But the judges are reacting negatively, as they should, saying, we don't believe you, prove it up. We want to hear this. We want to see that. No, you're wrong. And as long as that's happening, even if the administration is resisting the legitimacy or the impact of the court orders, trying to misread them or trying to ignore them, it's our job as lawyers to bring the administration back before those very same judges and say, here they are again, Your Honor. You said to do X, Y, and Z. They did half of X, none of Y, and 3 times as much of Z as anybody should have done. And so it's time to talk to them again. That's our job. The solution to lawlessness is more lawsuits, not less. I'm not giving up on the courts. Maybe you can accuse me of having a guy with a hammer that only sees nails out there, but guess what? The courts are an important nail. It's the one branch of government that is doing its job right now.
Daniel, do you see any trickle-down effect from what's happening in federal courts, how it impacts possibly the tribal laws, or how ignoring what happens in courts could just be another kind of adding on to stripping tribal laws?
Not yet. The concern, I think, which I think you raised, is that if they see someone do it, then, well, hey, why don't we try that too? Maybe we can do the same thing. But I agree with Sam's point. Exactly. It's like you don't turn away from it. You kind of step into it and lean into that whatever that is, right? And you kind of address that, and you, as lawyers, that's the tools we have, and it's a long game. And even though the term is short, maybe several years, it's still that's the term we're working under. And so I think that's the length of the work here. So.
We had one more audience question. I think, Sam, you started to touch on this, how people can plan on challenging the cancellation of grants and federal contracts under Biden climate laws. Is that lawsuits around those cancellations? Is it looking for, different funding, all of the above?
Yeah, one of the dynamics is, this kind of litigation can be contracts litigation, right? Like you're going in and saying the government breached a contract, and that's typically litigation that happens at the Court of Federal Claims in a different way. And it's not really the form in which we want to be bringing these things, because we view these not as breaches of contract, but as executive decisions to ignore contracts or to reject contracts. And so we're planning on challenging them and have challenged them. That's not planned. We are actually live in court and challenges about this. And we're arguing that these decisions violate the Administrative Procedure Act, that these are decisions to get rid of funding programs that have no basis in law and need to be set aside. So please know, Alec Bowman, that many grant challenges are ongoing. We're not the only organization. There are other organizations that are doing it, because IRA and IIJA money are, should be perhaps one of the biggest legacies of the Biden administration on the environmental front. And it's our job as public interest advocates to try to defend those investments and the people who relied on them.
So before we go, we want to end a little bit on a positive note. So Daniel, can you tell me what gives you hope right now, even in the turbulent time, politically, legally? What are the kind of signs of progress or power do you see?
In our world, I feel like we have the momentum headed the right way. We have a lot more coordination amongst ourselves. We have a stronger group at NARV than we've had ever. We have more capacity probably there to work across issues than we have before. And we also have a really strong willingness to engage and create partnerships outside too. So that gives me a lot of hope. And tribes, for all the difficult things, I think tribal nations are in a lot of ways at the strongest they've ever been too. And they've been able to assert things that by themselves with in-house counsel or with their outside counsel as well to kind of to cement their rights in ways that they've never been able to. So I think the opportunities and the ability of tribal nations to represent themselves as sovereign governments, I think, is stronger than it's ever been. And that's just really an empowering thing to show up for and to serve every day.
Sam, what are you seeing?
Well, the Supreme Court has broken my heart so many times over the last 20 years, I can't count. And, I see the glimmer of hope that they're going to stand up to this administration and say, nope. And I think they're properly choosing their spots carefully, but you get the sense that they're watching and reading everything, and that they're not going to let this go unanswered. That's one area of hope. The other area of hope I have is that, we have our summer law clerks coming in about a month, and we just get this incredible injection of energy from all of our summer law clerks, every one of whom shows up with just incredible talents that they're bringing to bear, life experiences, and just an energy to do this. And I feel like as long as our field is being watered by so much great new talent at all times, that just gives me hope and optimism that great people still want to do this work. They know that it's important. They know it's valuable. At my advanced age, if they think it's still worth doing, then I guess I should keep doing it.
Perfect. So on that note, I want to thank both of you again for this impactful discussion. And as we talked about the rollback of environmental protections under the Trump administrations, it's going to continue and have lasting impacts, but our fight for environmental justice is far from over. And it's up to each of us to stay informed, stay engaged, and support policies that prioritize the health of our planet and our communities. So be sure to check out Earthjustice and NARF's website for more information. And of course, don't forget to follow Alliance for Justice on all our social media channels to stay up to date on all events like this. And next month, we're going to be joined by Leah Littman, professor of law at the University of Michigan, former Supreme Court clerk, Strict Scrutiny podcast co-host, and author of the recent book, Lawless: How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. A registration link for that holding court in May has been put in the chat and will be emailed to all of those who registered for this week. So we really appreciate your participation, and we look forward to your continued engagement in our future discussions. Thanks again for tuning in, and we can't wait to see you next time.